Okay, good afternoon. Let us discuss yung extinguishment of obligations. Okay, bali, we already discussed yung sources ng obligation. Okay, we create the obligation, yung mga different kind of obligation. Ngayon, we will discuss naman yung mode of extinguishment. Kasi hindi naman pwedeng mag-exist ang obligation forever sapagkat walang forever. Kaya ano yung mga mode of extinguishment of obligation? Sabi ng Article 1231 ng Civil Code, bali ito yung payment or performance, loss of the thing due, by condonation or remission of debt, by confusion or merger of right or of creditors and debtor, by compensation, and by innovation. However, meron tayong mga other causes ng extinguishment ng obligation as follows, like rescission of rescissible contract, annulment of voidable contract, arrival of resolutory period, happening of resolutory period, and such other mode of extinguishment as provided under this code. Okay, now question. Okay, how about debt ng creditor? Is a debt of creditor a mode of extinguishment? Okay, the answer of course is no. Okay, kasi di ba ang sabi ng Article 1178, all rights acquired by virtue of obligation are transmissible. Kaya ang role is transmissible right siya, matatransferred lang to sa legal heirs. Pero kung non-transmissible right siya, of course, obligation is extinguished. Okay? How about debt ng debtor naman? Okay, is that a mode of extinguishment? The answer also is no. Okay? Kasi, ang obligation, ng debtor are also transmissible to the legal heirs. Pero subject to, limitation under second paragraph of 1311 that the heirs is not liable beyond the value of the property received from the decedent. Kasi kung walang property na naiwan, yung namatay, hindi liable ang legal heirs. Pero kung may property, mata-transfer yan sa legal heirs. Asset after deducting liability. Okay, another is how about marriage? Is a marriage a mode of extinguishment? Okay, general rule is of course is no. Okay, pero meron ba kayo naiisip na provision under the law na yung marriage ay pwedeng mag-cause ng extinguishment? The answer is yes, sa may law on partnership. Kasi under the law on partnership, di ba, as to object, pwede siyang universal partnership, pwede siyang particular partnership. Pag universal partnership, pwede itong universal partnership of all present property or universal partnership of all profit. Okay, second yung particular partnership. Okay, pero take note sa universal partnership kasi, whether of all present property or all profit, ang nature niyan is like donation. That's why those who are prohibited to give donation to each other cannot enter into a universal partnership. Okay, sino ba yung mga prohibited to give donation to each other? Di ba? Nangunguna na yung husband and wife. Example, halimbawa si ABC, nag-form sila ng universal partnership of all present property. Later on, si A and B got married. In that case, ground dyan for automatic dissolution. Kaya lumalabas yung partnership is automatically dissolved. Pero kung halimbawa si ABC nag-form ng particular partnership and subsequently A and B got married, hindi siya magkakos ng extinguishment. Okay? Hindi siya magkakos ng dissolution. Kasi sabi ng Supreme Court, even though ang husband and wife prohibited mag-enter ng universal partnership, whether of all present property or all profit, walang prohibition sa particular partnership. Kaya yung subsequent marriage ng partner, at ito ay particular partnership, hindi siya magkukos ng dissolution. Okay, unahin natin yung first mode of extinguishment. Yung payment or performance. Okay, if you look Article 1232, napaka-broad ng definition ng payment. Kasi sabi dito, payment means not only the delivery of money, but also the performance in any manner of an obligation. Kaya kasama dito yung performance sa obligation to give, to do, saka not to do. Okay? Kaya napaka-broad nung definition ng payment under 1232. Okay, general rule, a debt shall not be understood to have been paid unless the thing or service in which the obligation consists daw has been completely delivered or rendered as the case may be. Kaya ang general rule, para ma-extinguish ang obligation, okay, there must be a complete payment. Meaning the payment must be total or it must be complete. Kasi pag ang payment is partial or irregular performance, the rule is that the creditor may rightfully refuse to accept payment. And the obligation is not extinguished. Pero may dalawang exception na even there is a partial or regular performance, magkokos siya ng extinguishment. Number 1, yung Article 1234 at number 2, yung Article 1235. Now, under Article 1234, ito tinatawag nating substantial performance in good faith. Kasi yung sabi dyan, kapag meron daw substantial performance in good faith, okay, then the obligation of the debtor is extinguished, but you need to deduct the damage suffered by the obliging. Okay, example. I am the debtor, you are the creditor. My obligation to you is to deliver 10,000 sacks of rice. Okay? Now, however, the debtor delivered only 9,500. And the debtor failed to deliver the 500 deficiency because of rice shortage. Okay, and the debtor is willing to deliver the deficiency. Yun nga lang, the debtor cannot deliver the deficiency for circumstances beyond his control. Okay, now since merong substantial performance in good faith, then the obligation of the debtor is now extinguished, but you need to deduct the damage suffered by the obliging. Meaning, the creditor or the other party is required only to pay based on the 9,500, not based on 10,000 sacks of rice. Kasi otherwise, magre-result naman siya ng unjust enrichment at the expense of another. Okay, yung number 2, okay, yung principle of estoppel. Okay, kasi ang rule kasi is that when the debtor daw tender payment which is incomplete or irregular, the creditor should not accept it. Or kung i-accept man to ng creditor, then the creditor should object. Huwag niya itong i-treat as complete payment. Kasi once na yung debtor ay nag-tender ng payment na incomplete or irregular, and the creditor accept it at treat niya to as complete payment, it means the creditor is guilty of estoppel. Kaya ang effect, the obligation of the debtor is now extinguished. Okay, now let us proceed sa rules on payment. Okay. Okay, ang first rule natin sa rules on payment para magkaroon daw ng extinguishment ng obligation by payment or performance. First rule, dapat both the debtor and creditor at the time of payment must be capacitated. Kasi pag ang debtor daw at the time of payment ay incapacitated kasi wala siyang predisposal ng thing due and capacity to alienate, the payment is not valid. And therefore, okay, his parent or guardian may recover the payment. Kasi halimbawa yung debtor dito at the time of payment pala incapacitated kasi baliw siya, insane or demented person, or a minor. The general rule is that his parent or guardian may recover the payment. Except pag nag-fall dun sa Article 1427 ng Civil Code on natural obligation. Nare-recall nyo ba yung 1427 on natural obligation? Di ba sabi doon, pag ang minor daw between 18 and 21 years of age, okay, nag-deliver ka ng either sum of money or fungible thing and the other party consume it in good faith, wala nang right of recovery. Kaya lumalabas, valid payment na siya. Okay? O, yun ha, bali lumalabas dito sa part ng debtor yun. Kaya dapat yung debtor ay capacitated. Dapat meron siyang predisposal ng thing due and capacity to alienate, otherwise the payment is not valid. Kaya yung parent or guardian niya, pwedeng ma-recover yung payment. Okay, pangalawang rule dito naman sa part ng creditor. Dapat yung creditor din at the time of payment must likewise be capacitated. Kasi pag ang creditor daw at the time of payment ay incapacitated, the payment is not valid. Exception, number 1, he kept the thing delivered. And second, to the extent that it redounded to his benefit. Kasi halimbawa yung creditor at the time of payment, baliw pala. Kaya pag binayaran siya ng debtor, payment yan at your own risk. Okay? Kasi ang rule dyan, the payment is not valid. Magiging valid payment lang siya if the creditor kept the thing delivered, and second, to the extent that it redounded to his benefit. Siyempre, malamang may tanong ka, sir, anong gagawin ko kung baliw yung creditor at the time of payment? Wag na lang bayaran. No. Kasi the obligation is not extinguished. Okay, anong dapat gawin, sir? Huwag kang mag-ordinary payment. Kailangan mo ng special form of payment which is consignation. I-deposit mo yung object sa court. Okay, so that the court may declare that the obligation is extinguished. Pero pag nag-ordinary payment ka, payment yan at your own risk. Pero kung halimbawa, baliw yung creditor, may utang natin, nung binayaran ng 10,000, tinago. He kept that thing delivered, valid yun. Or second, to the extent that it redounded to the benefit ng creditor. Kasi halimbawa, out of the 10,000 pesos, yung 6,000 ginastos niya for basic necessity. Tapos yung 4,000, na-loss lang niya sa gambling. Okay, tinayan ng Cara Cruz, di ba? In that case, valid yung 6,000, ang invalid lang yung 4,000. Kasi yung 6,000 pesos, nag-benefit yung creditor. Kasi kung mga basic needs yan, or basic necessity. Another rule, sabi ng batas, payment must be made only to the creditor, his successor in interest, or any person authorized to receive payment. Kaya dapat ang bayaran mo lang si creditor, o kaya kung patay na to, yung kanyang successor in interest, or any person authorized to receive payment, yung kanyang duly authorized agent. Kaya payment to third person is not valid, or payment to stranger is not valid except when it redounded to the benefit of the creditor. In fact, sabi ng Supreme Court, pag ang binayaran mo stranger, payment yan at your own risk. Kasi ang presumption dyan, hindi nag-benefit ang creditor. Kasi ang burden of proof nasa part ng debtor to prove that payment to third person redounded to the benefit of the creditor. Okay, pero meron tayong tatlong exception. That payment to third person is valid because the law presumed that, it redounded to the benefit ng creditor. Okay, number one, subrogation. Second, ratification. And third is the doctrine of estupend. Ano ba yung subrogation? When after payment to a third person daw, the third person subrogate to the right of creditor. Number two, yung payment ng debtor sa third person was ratified by the creditor. And number three, when through the creditor's conduct, it led the debtor to believe that a third person is duly authorized to receive payment. Okay, in that case, the payment to stranger is valid. Okay, kaya tandaan yung maigi ha, ang babayaran mo lang dapat ay creditor, successor in interest, or person authorized to receive payment. Kasi payment to stranger is not valid except when it redounded to the benefit of the creditor. At ulitin ko, sabi ng Supreme Court, pag ang binayaran mo stranger, payment yan at your own risk. Kasi ang burden of proof nasa part ng debtor to prove that payment to third person redounded to the benefit of the creditor. Okay, another rule. Sabi ng batas, the creditor daw cannot be compelled to accept performance made by a third person having no interest in the fulfillment ng obligation. Ibig sabihin, ang pwede lang mag-compel sa creditor to accept payment, number one, debtor. Pangalawa, third person daw na may interest sa fulfillment ng obligation. Sino yun? Guarantor, surety, pledgor, mortgagor. At pangatlo, third person na walang interest sa fulfillment ng obligation pero dapat may stipulation. Kasi kung total stranger ka, binabayaran mo yung creditor, the creditor may refuse to accept payment by a third person. Kasi ang reason dyan, sino ba to? Sino ka ba? Third person. Stranger ka. Pero the moment the creditor accept the payment of third person, then the obligation is extinguished. Ang issue na lang ngayon dito, can a third person ask reimbursement from the debtor? Ngayon, meron itong dalawang scenario. Number one, yung payment ng third person sa creditor, wala siyang intent to be reimbursed. And second, yung payment ng third person sa creditor, meron siyang intent to be reimbursed ng debtor. Okay, unahin natin yung wala siyang intention to be reimbursed. Sabi ng batas, payment made by a third person without intention of being reimbursed shall be deemed a donation. Pero it requires the consent of the debtor. Kasi para lumalabas dito, donation yan. Kaya kailangan may acceptance ng donee, which is the debtor. Okay? Kasi kung walang acceptance ng debtor, okay, walang valid donation. Kaya makaka-recover ka pa rin dito to the extent that the debtor benefited. Pero kung halimbawa, ang payment ng third person sa creditor, meron siyang intent to be reimbursed. Okay? O, sabi ng batas naman, payment made by a third person, okay, without knowledge. Okay, or with knowledge, but against the will of the debtor, would entitle him only for beneficial reimbursement. Pero pag ang payment ng third person sa creditor is with consent ng debtor, entitled ka sa tinatawag na legal subrogation. By the way, pag sinabing legal subrogation, it means substitution of creditor lang siya. Kaya papalitan lang ng third person whatever be the right of creditor. Okay, papalit lang ako sa right nito. Kaya kung halimbawa, hindi nagbayad si debtor, pwedeng habulin ng creditor yung guarantor. Pero pag halimbawa, ang payment ko dito ay walang consent nito, kasi walang knowledge nito, o kung may knowledge man against his will, o di entitled ka lang for beneficial reimbursement. Walang legal subrogation. O, bali yan yung summary ng rules on payment. Okay, now, isa-isahin ko yung provision sa law para makita nyo, para ma-recall nyo rin yung sinabi ko rito. Okay, punta tayo sa Article 1239. Sabi dyan, in obligation to give daw, payment made by one who does not have the predisposal of the thing due and capacity to alienate, it shall not be valid without prejudice to the provision of Article 1427 under the titles on natural obligations. Kaya sabi ko nga sa inyo, dapat yung debtor at the time of payment must be capacitated. Kasi kung ang debtor at time of payment is incapacitated kasi wala siyang predisposal ng thing due and capacity to alienate, the payment is not valid except pag nag-fall ng 1427 on natural obligations. Kasi kung minor to, nag-deliver ka ng sum of money or fungible thing at ito na-consume in good faith, valid payment na siya. Now, sa 1236 naman, okay, sabi dyan, the creditor daw is not bound to accept payment or performance by a third person was no interest in the fulfillment ng obligation unless there is stipulation to the contrary. Kasi di ba sabi ko kanina, ang pwede lang mag-compel sa creditor to accept payment, number one, syempre debtor. Pangalawa, third person na may interest sa fulfillment ng obligation, ito yung guarantor, surety, pledger, mortgagor. At number three, third person ka na walang, okay, third person ka na wala kang interest sa fulfillment ng obligation pero dapat may express stipulation. Okay? Now, okay? Kaya pag ang third person ay nagkaroon ng payment dito, totally stranger, pwede siyang i-refuse ng creditor. Yun nga lang, sabi natin, pag ang third person binayaran to at inaccept ng creditor, then the obligation of the debtor is extinguished. Okay? Now, sabi dito sa second paragraph, whoever pays for another may demand from the debtor what he has paid. Except that if he paid without the knowledge or against the will of the debtor, he can recover only so far as the payment is beneficial to the debtor. Kasi once na ang payment ng third person dito, okay, without knowledge nito, okay, o kung may knowledge man against his will, entitled ka lang for beneficial reimbursement. Pero take note, once na ang payment nito dito, ay with consent ng debtor, entitled ka sa tinatawag na legal subrogation. 1238. Payment made by a third person that does not intend to be reimbursed by the debtor is deemed to be a donation, which requires thou the debtor's consent. But the payment daw is in any case valid as to the creditor was accepted it. Okay, kaya di ba sabi ko, pag ang payment nito dito, wala siyang intent to be reimbursed, that is deemed a donation, pero it requires the consent ng debtor. Now, let us illustrate. Halimbawa, okay, ito yung jeep. Okay, yung driver is the creditor kasi meron siyang right to receive the fare. Ito naman yung debtor, si passenger A. Tapos ito naman si passenger B. Okay? Now, kunwari, nakasabay mo yung kaklasmate mo. Okay? Now, gusto mo sanang ibayad yung kaklasmate mo. Okay? Kaya, kunwari ang fare is 8 pesos, kaya okay, nag-abot ka ng bayad sa creditor ng 8 pesos times 2, 16. Pero ang problema itong debtor, saksakan ng araw, kaya sabi niya, naku, wag talaga, wag. Okay? Kaya ibig sabihin, hindi inaccept ng debtor yung act of generosity ng third person. Kaya lumalabas, okay, there is no valid donation. Kaya ang question dito, makakakuha ba ng reimbursement ang third person sa debtor? The answer of course is yes. To the extent that the debtor benefited. Kaya makaka-recover ka ng 8 pesos. Pero let us modify. What if, itong si passenger A pala, merong student discount. 7 pesos lang ang kanyang fare. Kaya in that case, makaka-recover ka lang kay passenger A ng 7 pesos. Okay, makaka-recover ka kay creditor ng 1 peso based on the doctrine of solutio indebiti. Because something is received when there is no right to demand it and it was unduly delivered by mistake. Kaya dito ka mag-recover ng 1 peso at 7 pesos naman kay passenger A. Now, okay, under Article 1237 naman, sabi dito, whoever pays daw on behalf of the debtor without the knowledge or against the will of the latter cannot compel the creditor to subrogate him in his rights, such as those arising from mortgage, guarantee, or penalty. Kasi kung binayaran ng third person yung creditor dito, walang consent ng debtor o di hindi ka entitled for legal subrogation. Entitled ka lang for beneficial reimbursement. Kaya hindi mo pwedeng i-compel yung creditor na mag-subrogate ka sa right niya na nag-arise daw sa mortgage, guarantee, or penalty. Kaya lumalabas dito, pag ang debtor insolvent, hindi pwedeng habulin ng third person yung guarantor kasi walang legal subrogation. Entitled ka lang for beneficial reimbursement. Okay, now, example class, tingnan mo to. Halimbawa, yung debtor may utang kay creditor na 10,000. Okay? 10,000 pesos. Okay? Yung third person, binayaran yung creditor ng 10,000 without the consent ng debtor. Hindi ka entitled for legal subrogation. Entitled ka lang for beneficial reimbursement for 10,000. Ang problema, yung debtor later on insolvent, hindi ko pwedeng habulin yung guarantor. Okay, kasi nga walang legal subrogation. Okay, now let us modify. 10,000 yung obligation. Binayaran ng third person to with consent ng debtor. Di entitled ako for legal subrogation. Kaya pag ito insolvent, pwedeng habulin ng third person yung guarantor. Now, let us modify uli. Paano kung yung debtor may utang kay creditor na 10,000? Later on, the debtor, okay, o yung creditor, kunwari, may utang din kay debtor na 2,000. Di mag-o-offset yun. 8,000 na lang. Eh ito, ang third person, binayaran to ng 10 without the consent ng debtor. Magkano marirecover dito? Answer, 8,000 lang. Okay, to the extent that the debtor benefited. Eh paano kung may consent for instance ng creditor? Okay, answer is 8,000 pa rin. Okay, pero pwede kong habulin to pag insolvent to. Kasi kung halimbawa may 10,000 yung existing obligation tapos nag-offset na yung 2,000, it means 8,000 na lang yung outstanding. Kaya pwede ako mag-substitute dito. Pag nag-substitute ka, 8,000 lang ang pwedeng makolect dito. Kaya kahit may subrogation, makakakolect ka lang din ng 8,000. Pero yun nga lang, once na insolvent ito, pwede kong habulin yung guarantor. Okay? Mahabol mo yung guarantor dito for the 8,000 pesos. Okay, next, Article 1240. Sabi dyan, payment shall be made to the person in whose favor the obligation has been constituted or is successor in interest or any person authorized to receive it. Okay? Now, ibig sabihin, ang dapat ko lang ang bayaran, creditor. Kung patay na, successor in interest, or any person authorized to receive, okay, to receive it. It means he's duly authorized agent. Kasi nga, once nang binayaran ng debtor dito, stranger, okay, the payment is not valid. Okay, except when the payment is stranger redounded to the benefit ng creditor. At sabi ko nga kanina, okay, may under the law kasi, pag ang binayaran ng debtor ay stranger, payment yan at your own risk. Kasi ang presumption ng batas, hindi nag-benefit ang creditor. Kasi ang burden of proof nasa part ng debtor to prove that payment is stranger redounded to the benefit of the creditor. Pero I repeat, meron ditong 3 instances na yung payment nga sa third person valid. Yan yung subrogation, ratification, and the doctrine of esto. Okay, ito yung tatlong exception na. Ito yung subrogation. If after the payment daw, the third person acquires the creditor's rights. Number two, if the creditors ratify the payment to third person. At number three, if by the creditor's conduct, the debtor has led to believe that the third person had authority to receive payment. Yan yung principle of estoppel. Now, okay, by the way, pakicheck nyo nga itong nakalagay. Sabi dyan, payment to a person who is incapacitated to administer his property shall be valid. Ang ginawang statement ng batas dito, valid payment daw dito, provided nag-benefit to. Ako ginagawa ko, okay, ito yung ito yung paragraph na to. Payment to third person shall also be valid in so far is redounded to the benefit ng creditor. Kaya pag nagkaroon ako ng payment dito, okay, valid raw kung nag-benefit to. Ako kasi ginagawa ko, negative statement. Payment dito is not valid except when it redounded to the benefit ng creditor. Pero by the way, parehas lang naman siya. Para lang yan tinawag na half full or half empty. Okay? Pero mas preferred ko kasing gawin na negative statement siya. Yung payment ko dito is not valid except when it redounded to the benefit ng creditor. Tapos itong paragraph number 1 dito, ganon din, positive statement ang ginawa. Pag binayaran ng debtor yung creditor, valid raw. Provided he kept that thing delivered and second to the extent that it redounded to the benefit ng creditor. Ako naman ginagawa ko negative. Payment to creditor na incapacitated at the time of payment is not valid except he kept the thing delivered and second to the extent that it redounded to the benefit of the creditor. Parehas lang siya actually. Pwede nga half full or half empty. Okay, now let us proceed now sa Article 1242. Now, okay, illustration. Sabi dito, payment made in good faith to any person in possession of credit shall release the debtor. Example, D issued the promissory note payable to C, which read as follow, I promise to pay C 10,000 signed D. However, C misplaced the promissory note and it was found by X. Si X ang ginawa, inassign kay E. Si E, present for payment kay D, binayaran ni D si E. Ang question is that, is the payment valid? The answer of course is no. Why? Kasi ang possession ni E is not possession of credit, but only a document evidencing credit law. Kasi nakalagay sa promissory note, payable siya kay C. Pero ang binayaran ng debtor ay si E. Since may defect of title dito, invalid payment siya. Pero let us modify. Paano kung halimbawa si D nag-issue ng promissory note payable kay C which read as follow, I promise to pay C or bearer 10,000 pesos signed D. Tapos si C na misplace yung promissory note, it was found by X. Si X ni-negotiate ngayon kay E. Si E ni-negotiate kay F. Tapos si F, okay, in-acquired niya yan in good faith and for value. At na-attain niya yung status ng holder in due course. Tapos, present for payment kay D, binayaran ni D. Ang question, is the payment valid? The answer is yes. Sapagat yung possession ni F dito ay possession ng credit. Kasi payable siya kay C or bearer. And F is the bearer of the instrument. Okay, next. Let us proceed now sa Article 1243. Sabi dyan, payment made to creditor by debtor after the latter has been judicially ordered to retain the debt shall not be valid. O example. Okay, halimbawa, meron kang bank deposit. Okay, sa BPI, kunwari 1 million pesos. In this case, BPI is the debtor and the depositor is the creditor. Later on, BPI received an order of garnishment coming from the court. Ino-orderan ng korte yung BPI, okay, na yung bank account ng depositor under garnishment. Kaya ibig sabihin, dapat hindi na siya i-release ng BPI, ng bangko. Despite of the order of garnishment, BPI still release the fund to the depositor. The payment is not valid because that is a payment made in bad faith. Kaya yan yung 1243. Payment made to creditor by debtor after the latter has been judicially ordered. Di ba? May order of garnishment na nga to retain the debt, shall not be valid. Okay, now let us proceed now sa Article 1244. 1244 versus Article 1246. Okay, yung 1244, nag-a-apply sa determinate or specific thing. Yung 1246 naman, nag-a-apply sa generic or indeterminate thing. Okay, sa Article 1244, okay, sabi dyan, the debtor of a thing cannot compel the creditor to receive a different one, although the latter daw may be of the same value as or more valuable than which is due. Example, I am the debtor, you are the creditor. My obligation to you is to deliver a Toyota Altis with plate number XYC123. In that case, the debtor must deliver, okay, the thing itself, the Toyota Altis with plate number XYC123. Okay, and the debtor cannot compel the creditor to receive a different one, like a BMW or a Ferrari, without the consent of creditor. Okay? Pero syempre, kung ikaw yung creditor, tatanggapin mo yun. Di ba? Pero ang rule dyan is that you cannot compel the creditor to receive a different one, even though the substitute is more valuable nga, okay, than the thing which is due. Okay, kasi ang reason dyan, may possibility may sentimental value kunwari sa part ng creditor yung object. Kasi nga, determinate thing siya. Dapat i-deliver mo yung thing itself. Yung second paragraph naman, nag-a-apply to sa obligation to do or not to do. Kasi sabi dyan, in obligation to do or not to do, an act or forbearance cannot be substituted by another act or forbearance against the obligee's will daw. Example, I am the debtor, you are the creditor. My obligation to you is to repair the television set. In this case, hindi ko pwedeng sabihin na I will no longer, okay, repair the television set. I will just repair your washing machine. Kasi nga, okay, yung act or forbearance daw, hindi siya pwedeng i-substitute ng another act or forbearance against the obligee's will. Kung walang consent, of course, yung creditor. Yung 1246 naman, nag-a-apply ito sa generic or an indeterminate thing. Sabi dito, when the obligation consists in the delivery of an indeterminate or generic thing whose quality and circumstances thou have not been stated, the creditor thou cannot demand a thing of superior quality, neither can the debtor deliver a thing of inferior quality. The purpose of the obligation and other circumstances shall be taken into consideration. Example, I am the debtor, you are the creditor. My obligation to you is to deliver a horse. Of course, a horse is generic thing. In this case, the creditor cannot demand a racehorse because that is a superior quality. Neither the debtor deliver a disabled horse because that is an inferior quality. Kailangan daw tingnan niyo yung purpose ng obligation and other circumstances. Now, ano may ibig sabihin ng purpose ng obligation and other circumstances? Kasi halimbawa, I am the debtor, you are the creditor, my obligation is to deliver a horse. Generic nga siya, di ba? Pero yung creditor, engage sa racehorsing. O di dapat ang i-deliver ng debtor kay creditor, racehorse, kahit generic siya. Kasi yan yung lumalabas na purpose ng obligation and other circumstances. Pero kung halimbawa yung creditor, nag-engage naman siya sa pag-slaughter ng kabayo, di dapat ang i-deliver, edi yung kabayo din na i-slaughter lang din. Kasi yan naman yung purpose ng obligation and other circumstances. Okay, next, punta tayo sa Article 1247 ng Civil Code. Sabi dyan, unless it otherwise is stipulated, the extrajudicial expenses required by the payment shall be for the account of the debtor. With regard to judicial costs, the rules of court thou shall govern. Okay. Yung extrajudicial expenses, outside court expenses yan. Chargeable yan sa debtor. Why? Bakit debtor ang dapat magbayad ng extrajudicial expenses? Kasi ang reason daw dito, once nagkaroon kasi ng valid payment, magbe-benefit yung debtor. Reason? Because his obligation is now extinguished. Pero pagdating sa judicial cost, ang mag-a-apply ay rules of court. At ano ang sabi ng rules of court? Under the rules of court, ang dapat magbayad ng judicial cost is the losing party. Okay? Kaya halimbawa, dinimanda kita, talo ka, ikaw magbayad ng judicial cost. Dinimanda kita, talo ako magbabayad ng judicial cost. Pero meron niyang exception. Kasi ang sabi doon, dapat ang magbayad yung losing party. Pero merong wide discretion ang court na i-distribute ang judicial cost equally between the party. Kaya pwedeng dinimanda kita, natalo ka or natalo ko, pwedeng 50-50 pa rin. Kasi pwedeng i-determine ng court na yung judicial cost ay i-distribute equally between the party. Pero syempre, in general rule is judicial cost is chargeable to the losing party. Now, let us proceed now sa Article 1248 ng Civil Code. Sabi dyan, unless there is express stipulation to that effect, the creditor cannot be compelled partially to receive the prestations in which the obligation consists, neither may the debtor be required to make partial payment. Okay? Ang rule lang sa 1248 is the payment must be total. Kasi the creditor cannot be compelled to accept partial payment, neither the debtor be compelled to make partial payment. Kasi dapat nga, the payment must be complete. Pero pansinin mo may exception sa second paragraph. Sabi yan, however, when the debt daw is part liquidated and in part unliquidated, the creditor may demand and the debtor may effect the payment of the former without waiting for the liquidation of the latter. Okay, example. Okay, I am the debtor, you are the creditor. I am liable for 120,000 payable in 12 equal installment starting January up to December of 2020. Now, assuming yung January installment payment nag-due na, in that case, the creditor may demand for the 10,000 without waiting for the February up to December. On the other hand, the debtor may pay for the January installment payment, which is 10,000, without waiting for the February up to December. Okay, kasi nga, okay, liquidated na yung 10,000 na due for January installment, pero kung February up to December, hindi pa siya, unliquidated pa. Okay? Now, pero question, what if the debtor failed to pay the 10,000 na due ng January? Okay? Nag-due na yung January, nag-default ang debtor. Ang ginawa ng creditor, dinimanda ang debtor for the entire 120. Anong mangyayari? Dismiss yung 110,000. Pero mag-proceed for the 10,000. Why? Kasi yung 110,000, premature pa yung cause of action mo. Kasi ang rule sa installment, whenever, di ba, each installment has a different period. At babalik tayo sa obligation of period ng sinasabi, whenever in an obligation of period is designated, it is presumed for the benefit ng both debtor and creditor. Kaya bawal maningil, bawal magbayad before arrival ng day certain. Kaya pwede lang mag-demand yung creditor for the 10,000 pesos na nag-due na noong January, pero yung February to December, since hindi pa siya due and demandable, hindi pa siya pwedeng mag-file ng case for the February up to December 31. Pero question, meron bang exception? The answer is yes, kung merong tinatawag na acceleration clause. Ano ba yung acceleration clause? Ito yung stipulation between the debtor and the creditor that if the debtor failed to pay any installment payment or the interest, the whole amount becomes due and demandable. Kaya kung nag-default yung debtor ng January installment payment, the creditor may now file for a case for the entire 120,000 pesos. Okay? Kasi nga, mag-a-accelerate yung, okay, magiging due and demandable yung entire obligation, okay, for the entire 120. Pero I repeat, kung walang acceleration clause, okay, the creditor can demand only for the 10,000 pesos which is due on January. Okay, next. Punta tayo sa Article 1249 ng Civil Code. Sabi dyan, payment of debt in money shall be made in the currency stipulated, and if not possible to deliver such currency, then in the currency which is legal tender in the Philippines. Kaya kung halimbawa nag-usap tayo ng US dollar, bayaran mo ko ng US dollar. Nag-usap tayo ng yen, bayaran mo ko ng yen. Pero kung hindi raw available yung US dollar or yen, then okay, ko-convert yan into okay, Philippine peso using the current exchange rate, which is legal tender in the Philippines. Pero ang problema, in 1950, nagkaroon ng tinatawag na Uniform Currency Act. Yan yung RA 529 which prohibit stipulation in foreign currency. Pero dito, ang void hindi yung obligation. Only the stipulation as to the foreign currency. Kaya automatic converted siya into Philippine peso. However, okay, nagkaroon naman ng tinatawag na Republic Act 8183. Ni-restore niya yung provision sa Article 1249. Kasi pag binasa mo yung Section 1 ng Republic Act 8183, sabi dyan, all monetary obligations shall be settled in the Philippine currency which is legal tender in the Philippines. However, the parties may agree that the obligation or transaction shall be settled in any other currency at the time of payment. Kaya ibig sabihin, kung mayroon tayong usapan ng US dollar, bayaran mo ko ng US dollar. Kung may usapan tayo ng yen, bayaran mo ng yen. Kung hindi available, then i-convert siya into Philippine peso using the current exchange rate. Kaya technically, na-restored lang yung provision ng Article 1249 ng Civil Code. Second paragraph, the delivery of promissory notes payable to order or bill of exchange or other mercantile documents thou shall produce the effect of payment only when they have been cashed or when through the creditor, fault of the creditor, they have been impaired. Kaya, okay, example, I am the debtor, you are the creditor. I am indebted to you 400,000. Later on, the debtor, okay, I tender to you a check. Can the creditor refuse to accept check? Yes, because checks are not legal tender. A question, what if the creditor accept the check as a mode of payment? Is the obligation extinguished? The answer is no. May extinguish lang siya, number 1, upon encashment. Number 2, when through the fault ng creditor, it has been impaired. At number 3, merong exception dun sa Central Bank Act na sinasabi na kapag ang okay yung check daw, dineposit na sa account ng creditor, na credit na sa account ng depositor, at meron na siyang absolute right na i-withdraw it without any further restriction, it will also produce payment. Okay, kasi ganito yun, di ba? Pag nakatanggap ka ng check, dalawang pwede mong gawin. Either number 1, i-deposit mo. Una pala, i-encash mo muna. Pag in-encash, payment ka agad. Or second, i-deposit mo. Pero ang problema, kung magkaibang bangko yan, dadaan sa clearing process. Okay? Kaya hanggat, kung hindi pa siya nag-clear, naka-credit sa account mo, pero naka-float. Ngayon, pag nag-clear na siya, doon mo lang siya pwedeng i-withdraw at any time without any further restriction. In that case, magpo-produce siya ng payment. Pero kung same bank siya, since online because of technology, automatic, pag naka-on as yan, okay, credit ka agad. Pwede mo na siyang i-withdraw at any time. Mag-produce ka agad siya ng payment. Tapos, last paragraph, sabi diyan, in the meantime, the action derived from the original obligation daw shall be held in abeyance. Ano ibig sabihin ng abeyance dito? Temporarily suspended, example. I am the debtor or the creditor. I am indebted to you for 100,000. Nag-tender ako sa iyo ng check at in-accept mo yung check as a mode of payment. Ang tanong, pwede bang mag-file ka agad yung creditor ng case against the debtor for collection of sum of money? No. Kasi yung original action mo dito, temporarily suspended muna. Kailangan i-present mo muna yung check sa drawee bank. Ngayon, pag yung creditor present yung check sa drawee bank at ito ay dishonored for lack of sufficient fund, okay, doon lang pwedeng mag-file ng case yung creditor against the debtor. Pero hanggat hindi pine-present ng nung creditor yung check sa drawee bank at di yan dinidishonor, it means yung original action ng creditor against the debtor temporarily suspended muna siya. Okay, next. Ano bang ibig sabihin ng legal tender? Okay, pag binasa mo yung Section 52 ng Republic Act 7653, okay, with respect to bills, lahat ng bills ay considered legal tender. Pero pagdating sa coins, meron siyang limitation. Kasi pag ang denomination ng coins ay 25 centavos and above, legal tender siya up to 50 pesos lang. Pero pag ang denomination coins ay 10 centavos or less, then legal tender siya up to 20 pesos. Now, kung halimbawa, ngayon, nagbayad ka kunwari ng, okay, 10 pirasong 10 peso coins. Hindi na yan legal tender under Section 52. Tama ba? Kasi lagpas ng 50 pesos siya. Kaya nga may nakalagay dyan na unless otherwise fixed by the Monetary Board. Kaya ito, nagkaroon ng delegation, okay, sa Monetary Board. That's why pursuant to okay, BSP Circular Number 537, Series of 2006, dated July 18, 2006, okay, in-adjust ang legal tender with respect to coins. Kaya pag ang denomination ng coins is 1 peso, 5 peso, 10 peso coins, legal tender siya up to 1,000 pesos na. Pag ang denomination ng coins naman is 1 peso, 5 peso, 10 peso, okay, 25 centavo coins. Sorry, okay, 1 centimo, sorry, 1 centimo, 5 centimo, 10 centimo, and 25 centimo coins, legal tender siya up to 100 pesos. Okay, in-adjust na yan. Kasi before, di ba, ang coins natin, yung 5 pesos before is bills. 10 pesos ay bills. Okay? Ngayon, lumalabas yung 5 peso and 10 peso, okay, coins na siya. Kaya lumalabas hanggang 1,000 pesos. Pero malamang may question ka, paano sir kung 20 pesos later on? Baka mag-issue ng panibagong circular dyan ang BSP. Baka i-adjust uli kung magkano legal tender with respect to coins. Okay? Now, or baka hindi rin adjust, pero wala pa yung 20 pesos dito. Okay? Kasi yung 20 pesos ay bills. Kaya lumalabas, legal tender yan for any amount. Okay, now, ito yung circular na inisyo ng BSP. BSP Circular number 537. Basahin natin. Pursuant to Section 52 of Republic Act number 7653 and Monetary Board Resolution number 862 dated July 6, 2006. The maximum amount of coins to be considered as legal tender is adjusted as follows. Bali, 1,000 pesos for denomination of 1 peso, 5 peso, and 10 peso coins daw. And 100 pesos for denomination of 1 centimo, 5 centimo, 10 centimo, and 25 centimo coins. Now, this circular thou shall take effect after 15 days following its publication in official gazette or in newspaper of general circular. For the Monetary Board, okay, Governor Amando M. Tetango Jr. Okay, July 18, 2006. Okay, now let us proceed now sa Article 1250. Sabi dito, in case an extraordinary inflation or deflation of the currency stipulated should supervene, the value of the currency at the time of the establishment of the obligation shall be the basis of payment unless there is an agreement now to the contrary. Okay, by the way, bago mag-apply ang 1250, kailangan it must be extraordinary. Kasi baka mamaya kung ordinary inflation or deflation lang siya, walang application ng 1250. Kailangan it must be an extraordinary inflation or deflation. Pero tanong mo malamang, paano namin malalaman kung merong extraordinary? Okay, sabi ng Supreme Court, kailangan meron niyang declaration coming from the appropriate government agency. Okay, and of course, I'm referring to the Bangko Sentral. Pangalawa, dapat obligation arising from contractual relation. Kasi kung halimbawa, eminent domain yan. Okay, ano nga eminent domain? Ito yung inherent power ng government to take private property for public use upon payment of just compensation. Kaya dapat merong, okay, ito, hindi naman to galing sa contractual obligation. Kaya lumalabas, wala rin dapat application yung 1250. Kasi yan ay, okay, obligation arising from law. Okay, at pangatlo, itong 1250 ay subject sa stipulation. Okay, ibig pwedeng ilagay na stipulation. Example, kung meron kayong bank account, meron kayong savings, kunwari, nakadeposit sa BDO. Tingnan mo yung passbook nyo. Sa last page nun, may nakalagay na provision na okay, may nakalagay na provision dun sa passbook nyo. Sa last page normally, nakalagay other provisions. The provision under Article 1250 of the new Civil Code is not applicable in this bank deposit. Okay, kasi nga naman kung mag-a-apply yan, baka malugi yung bangko niyan. O example meron kang bank deposit na 1 million sa BDO. Later on, nagkaroon ng extraordinary inflation. Lahat ng bilihin, abay nag-times 5. Bari, yung isang sakong bigas, 2,000 lang, ngayon 10,000 na because of extraordinary inflation. Nag-times 5 lahat. Kaya, dapat ang bayaran ng bangko sa'yo, times 5 din. Kaya kung meron kang bank deposit na 1 million, times 5, 5 million. Pero since nakalagay na stipulation na hindi mag-a-apply yung provision ng Article 1250 ng New Civil Code on this bank deposit, then the bank is required only to pay you 1 million. Okay, kasi subject yan sa stipulation. Kaya normally kung ikaw ay debtor, dapat ilagay mo siyang stipulation. Kasi hindi mo masabi, baka biglang magkaroon ng extraordinary inflation later on at dineclared ng Bangko Sentral, di magbabayad ka ng 5 million. Tulad nito, debtor, creditor, 1 million loan, 5 years to. Pero ang problema, later on, nagkaroon ng extraordinary inflation, nag-times 5 lahat ng bilihin, 500%. Then, the debtor is required to pay the creditor, which is 1 million, times 5. Kaya 5 million pesos. Pero kung nilagay mo siyang stipulation, kahit merong extraordinary inflation, the debtor is required only to pay the creditor for 1 million pesos. Kaya tandaan nyo, subject yan sa agreement. Okay, now regarding place of payment, punta tayo sa place of payment. Sabi ng Article 1251, payment thou shall be made in the place designated in the obligation. Okay? Kaya ibig sabihin, kung meron kayong agreement ng place of payment, sundan nyo yung agreement ng place of payment. Paano kung walang agreement ng place of payment? Sabi ng batas, alamin mo muna. Pag yan daw ay determinate object, nasaan yung object at the time the obligation was constituted? Pero sabi dito, but in any other cases, the place of payment would be the domicile of the debtor. Now, question, ano ba ibig sabihin ng domicile? Is domicile same as residence? Legally speaking, magkaiba ang domicile sa residence. Kasi pag sinabi natin domicile, even though you are not physically present, pero meron kang intention to return, it means hindi mo in-abandon yung old domicile mo. Pero yung residence kasi, normally, yan yung physical presence mo. Hindi ka pwedeng magkaroon ng multiple domicile. Kasi bago ka makapag-create ng another domicile, kailangan meron ng animus non revertendi. Meaning, wala ka ng intention to return back. Okay, pero pwede kang magkaroon ng multiple residence. Kasi yan yung physical presence mo. Now, I think yung tinutukoy na domicile dito, it should be residence. Yung physical presence, of course, ng debtor. Okay? Now, if the debtor daw changes domicile in bad faith or after he has incurred in delay, the additional expenses daw shall be borne by him. Kasi baka mamaya, yung debtor pala, nasa Manila siya, he acted in bad faith, nag-transfer sa Mindanao area. Okay? Or nag-transfer sa Visaya area para lang maiwasan tong creditor. In that case, yung additional expenses daw chargeable to him. Sabi din, these provisions daw are without prejudice to venue under the rules of court. Now, question. Anong pinagkaiba ng venue sa jurisdiction? Kasi pag sinabing venue, place of action. Samantalang pag sinabing jurisdiction, ito yung authority ng court to hear and decide the case. At take note, venue is subject to stipulation, wherein jurisdiction is not subject to stipulation because these are fixed by law. Okay, example ng jurisdiction. Okay, pagdating sa mga forcible entry and lawful detainer, like ejectment suit, nasa exclusive jurisdiction niya ng MTC, Metropolitan Trial Court or Municipal Trial Court. Pag pinail yan sa RTC, action for ejectment suit, dismiss kagad ang case mo for lack of jurisdiction. Kasi under the law, ang jurisdiction, ang merong exclusive jurisdiction with respect to unlawful detainer saka forcible entry is the MTC. Okay, another example, illegal dismissal case. Nasa exclusive jurisdiction niya ng labor arbiter ng NLRC. Pag pinail mo yan sa MTC or RTC, automatic, dismiss ka agad ang case mo for lack of jurisdiction. Another example, yung mga another example. Pagdating sa mga high-ranking public official with salary grade of 27 and above, that is within the jurisdiction of the Sandigan Bayan. Pag pinail yan sa MTC, RTC, dismiss ang case for lack of jurisdiction. Yan jurisdiction ang pinag-uusapan. Pero sa venue, place of action. Pag real action daw, nasaan yung location ng property. Pero pag personal action, pwedeng mamili yung plaintiff either sa principal place of business sa residence ng plaintiff or principal place of business sa residence ng dependent at the option ng plaintiff. Pero ito, subject to stipulation. Now, let us proceed now sa special form of payment. Now, meron tayong 4 na special form of payment. Ito yung dation in payment or sometimes ang tawag dation and pago, adjudication and pago. Covered ng Article 1245 ng Civil Code yan. Sabi doon, dation in payment whereby properties alienated in satisfaction of debt in money shall be governed by the law and say. Pangalawa, application for payment. Payment by session, saka tender of payment and consignation. Pero by the way, may natanong kasi before na ganito. Which of the following is not really a special form of payment? Ang isasagot mo ay application for payment. Why? Because there is nothing special in application for payment. Walang kakaiba sa application for payment. Okay, now tingnan natin na isa-isahin natin. Sa dasyon and pago kasi, meron kang existing obligation in money. Pero in-extinguish mo ito, okay, in kind. O, di ba kakaiba siya? Kasi ang obligation mo, money, pero in-extinguish siya by payment in kind. How about application for payment? Sa application for payment, okay, merong isang debtor, merong isang creditor. Pero may 2 or more debts ka on the same creditor. Ba, may utang kang 10,000. 10, 10, 10, 10, 10. Later on, the debtor pay 10,000. Sasabihin lang ng debtor, yung 10,000 i-apply either sa first, sa second, sa third, fourth, or fifth obligation. O, di ba? Walang kakaiba. Samantalang sa payment by session, okay, merong isang debtor, may several creditors. Ang gagawin ng debtor, i-assign daw niya or isisin niya lahat ng properties niya na subject sa attachment execution. Pero take note ha, hindi niya itatransfer yung ownership. Kasi ino-authorize lang niya yung several creditors na i-dispose yung property. At may extinguish lang ang obligation ng debtor only to the extent ng net proceeds. Kaya kakaiba rin siya. Kasi dito na-extinguish yung obligation through assignment of property. At yung number 4 naman, yung tinatawag na tender of payment and consignation. Dito, na-extinguish yung obligation by depositing the object into court disposal. O di ba, kakaiba rin siya. Kaya since ang question, which of the following is not really a special form of payment? Okay, the answer should be an application for payment. Okay, now punta tayo doon sa dasyon and pago or dation in payment. Now, sabi ng Article 1245 ng Civil Code, dation in payment whereby properties alienated to the creditors in satisfaction of debt in money shall be governed by the law of sale. Kaya ibig sabihin, governed daw to ng law on sale. Eh ano ba pinagkaiba ng contract of sale versus dasyon and pago? Okay, first, in a contract of sale, walang pre-existing obligation. Samantalang sa dasyon and pago, merong pre-existing obligation. Pangalawa, in contract of sale, it create an obligation arising from contract. Samantalang sa dasyon and pago, it extinguish an obligation because these are a special form of payment. Third, sa contract of sale, ang cost daw sa part ng seller, price. While ang cost sa part ng buyer, yung delivery ng determinate object. Kasi di ba ang definition class ng cost or consideration sa law on contract, yung cost or consideration daw, ito yung object or prestation na pre-promise ng other party. Eh di ba ang promise ng seller sa buyer, yung delivery ng determinate object. Kaya ang cost sa part ng buyer, yung determinating. Ang promise naman ng buyer sa seller, payment ng price. Kaya ang cost sa part ng seller is the price. On the other hand, in dasyon and pago, ang cost sa part ng debtor is the extinguishment of his obligation. Ang cost naman sa creditor, yung alienation ng thing in satisfaction of debt in money. And last, sa contract of sale, there is a greater freedom in fixing the price. The why? Kasi since wala pang pre-existing obligation, the vendor and the vendee are free to stipulate as to the price. Samantalang sa dasyon and pago, since meron ng pre-existing contractual obligation, nalilimit daw yung pag-fix ng price. Okay, illustration. I am the debtor, you are the creditor. I am indebted to you for 10,000 pesos. Pero ang sabi ng debtor, Mr. Creditor, I have no money, but I have refrigerator. Can I alienate my refrigerator in satisfaction of debt ni money? Pag pumayag yung creditor doon sa payment ng refrigerator, ang effect, the entire obligation ng debtor is extinguished. Pero let us modify. Paano kung sinabi ng creditor, pwede, tanggapin ko yung refrigerator mo, pero ang problema, ang dami ng gas-gas, may kalawang pa. Kaya dapat ang value niyan should be 8,000 lang and both parties agree. In that case, partial extinguishment. Extinguished up to 8,000. That's why the debtor is still liable to pay the creditor for the difference of 2,000. Pero again, let us modify. Eh paano kung agreement nila, dapat 15,000? Kasi maganda pa raw yung value. Maganda pa, bago lang yung refrigerator. And both parties agree that the value should be 15,000. In that case, then the entire obligation extinguished. But okay, the creditor is required to pay the difference of 5,000 pesos. Okay, let us modify again. I am the debtor, you're the creditor. I am indebted to you for 10,000 pesos. Sabi ko, Mr. Creditor, I have a proposal. Let us extinguish my obligation by alienating the refrigerator. Pumayag yung creditor. But later on, okay, after a week, na-determine ng creditor na yung value pa lang nung car is 8,000 lang. Ang question is that, can the creditor compel the debtor to pay the difference of 2,000? The answer is no. Kasi since wala silang agreement ng appraisal of value at the time of alienation, ang effect is that the entire obligation is extinguished. Now, next, punta tayo sa another mode of extinguishment. Ito yung tinatawag na application of payment. Ngayon, ito yung requisite ng application for payment. Dapat one debtor, one creditor. Pangalawa, may 2 or more debts daw on the same creditor. Next, dapat the debt must be of the same kind. Kaya dapat pare-parehas 10,000 yan. Okay, pes mga sum of money. Or pwede rin sugar at same quality. Next, the payment of the debt applied must be due. Kasi baka mamaya due. Ito due next month. Hindi mo pwedeng i-apply dito. And payment must not sufficient to cover all the debts. Kasi ba nagkaroon ng payment ang debtor na 50,000, walang application for payment because the entire obligation is extinguished. Okay, now, tingnan natin ang illustration. Okay, 10,000, 10,000, 10,000, 10,000, 10,000. Debtor, creditor. Sabi ng batas, yung debtor muna yung gagawa ng application for payment. Kaya kung nagkaroon siya ng payment ng 10,000, pwede niyang i-apply either sa first, second, third, fourth, or fifth. Pero kung halimbawa, due, eto due next month, hindi ko pwedeng i-apply dito. Kasi hindi pa siya due and demandable. Kung halimbawa, 10,000, okay, 10,000, 10,000, 10,000, ito 10,000 worth of sugar, hindi ko rin siya pwedeng i-apply dito sapagkat hindi siya of the same kind. Okay? Kaya kung sugar ha, hindi ko pwedeng i-apply. Paano kung halimbawa, nakalagay on or before? Can the debtor apply the 10,000 to this obligation? The answer is yes. Why? Kasi yung benefit ng period nasa debtor. Ngayon, pag ang debtor daw hindi gumawa ng application for payment, the creditor will make an application for payment by indicating on the receipt. O, kaya pwede kong i-apply lahat dito. Pero kung halimbawa, nakalagay sa problem na itong obligation 5 is on or before, can the creditor make an application for this obligation? The answer is no. Kasi ang benefit ng period na kay debtor, wala kay creditor. Okay? Kasi nakalagay on or before. The benefit of period belongs only to the debtor. Unless nakalagay sa problem that, okay, 10,000 June yan next month, pero the creditor may demand on or before. Pwede kong i-apply dito. Okay? I repeat, sa application of payment, ang rule is the debtor has the first choice. Must indicate at the time of payment. If the debtor daw does not apply, the creditor may make the designation. Kaya pwede niyang i-specify sa receipt which debt is being paid. Pero pag wala rin ginawa ang debtor, walang ginawa ang creditor, i-apply daw siya sa pinaka-most onerous obligation. Ano bang ibig sabihin ng most onerous obligation? Ito yung pinakamabigat sa part ng debtor. O, gawa lang tayo ng konting guide. Halimbawa, okay, isang interest bearing saka non-interest bearing. Mabigat yung interest bearing. Okay, parehas interest bearing, isang 10%, isang 14%. Mabigat yung 14%. Okay, isang with penal clause, isang without penal clause, mabigat ang may penal clause. Isang naka-mortgage, isang unsecured, mabigat yung naka-mortgage kesa sa unsecured. Isang solo, saka isang solidary, mabigat yung solo than solidary. Okay, ngayon kung okay, same nature and burden siya, i-applied mo na raw siya proportionately. Kaya kung halimbawa, lahat yan same nature and burden, kunwari, wala to kunwari ha, same nature and burden. Lalabas dyan, kung nagkaroon ng payment ng 10,000, walang ginawa yung debtor, wala rin yung creditor, tingto 2,000 siya. Kasi a-apply mo siya proportionately. Okay? Next, punta tayo dito. By the way, sabi nga pala ng 1253, if the debtor produce interest, payment of the principal shall not be deemed to have been made until the interest has been covered. Kasi ba in payment, you need to apply first the payment to the interest before you can apply to the principal. Kaya nga meron tayong presumption under Article 12, okay, Article 1177, na if the creditor issue a receipt pertaining to the principal without reservation as to the interest, it will give rise to the presumption that the interest is already paid. Okay? Now, i-correlate mo yan dito sa 1253. Kasi pag nagkaroon ng payment ang debtor, hindi niya pwedeng insist na yung payment i-apply ka agad sa principal kung hindi pa bayad yung interest. Okay? Now, unless of course, meron silang contrary stipulation. Kaya nga merong yung provision sa Article 1177 is merely rebuttable presumption. Kasi pwedeng mag-present ang creditor ng contradictory evidence na hindi pa bayad yung interest. Okay, now punta tayo dito sa another special form of payment which is payment by cession. Sabi ng 1255, the debtor daw may cede or assign his property to his creditors in payment of his debt. Now, this cession, unless there is stipulation to the contrary, shall only release the debtor from responsibility for the net proceed of the thing assigned. The agreements thou which on effect of the cession are made between debtor and his creditor shall be governed by special law. By the way, sa payment by cession, ang concept niya, isang debtor na kung napakaraming creditor. Okay? And the debtor is already insolvent. Okay? Kaya ang gagawin ng debtor, i-assign daw niya or isi-cede niya lahat ng properties niya na subject to attachment execution. Pero I repeat, hindi niya ililipat ang ownership dito. He is merely authorizing the creditors to dispose the property. Okay, para pag nabenta to, yung proceed, okay, ma-extinguish lang ang obligation ng debtor onto the extent ng net proceed. Kasi halimbawa, ang utang ng debtor kay creditors, sabihin natin class na 100,000. 40,000. Nabenta lang yung properties kunwari ng 20. Ang mangyari dyan, ma-extinguish lang yung obligation ng debtor only to the extent ng 20. Kaya liable pa rin yung debtor sa creditor. Pero syempre, as of today, as of this moment, hindi pa makakakolect yung creditor. Kasi kailangan hintayin ng creditor na gumanda ang financial position ng debtor bago sila makakolect. Now, kaya tandaan niyo ha, ito yung requisite niya, one debtor, okay, pero may two or more creditors. Next, the debtor must be insolvent. And the cession assignment must be accepted by creditors. Now, okay, ano ang distinction, okay, between, wait lang. Okay, ano ang distinction between the dation in payment versus payment by cession? Now, number one distinction, sa dasion in pago kasi, one debtor, one creditor lang. But in payment by cession, one debtor but there are several creditors. Second, in dasion in pago, the debtor is not insolvent. But in payment by cession, okay, insolvency of the debtor is required. Okay, number three, in dasion in pago, okay, hindi niya, it covered only one or more specific property, but not all. Kumbaga, kung refrigerator lang, TV or refrigerator, pero hindi lahat ng properties. Pero sa payment by cession, it covers all properties ng debtor subject to attachment and execution. Next, in dasion and pago, when the debtor alienate the thing in satisfaction of debt in money, ownership is transferred to the creditor. But in payment by cession, walang transfer of ownership. Okay, the debtor merely authorized the creditor to dispose the property. Another distinction sa dasion and pago, okay, it extinguished the entire obligation except by may contrary stipulation. Ibig sabihin, when the debtor alienate the thing in satisfaction of debt in money, ang general rule, extinguish yung entire obligation unless may contrary stipulation. Pero sa payment by cession, ang rule, may extinguish lang ang obligation ng debtor only to the extent ng net proceed lang unless may contrary stipulation. And last, in dasion and pago, isa raw tong act of novation, pero sa payment by cession, hindi raw to act of novation. Ano ba yung sabihin ng novation? Novation is a mode of extinguishing an obligation either by changing the object or principal condition, or pwedeng substitution ng debtor or by subrogating a third person in place of creditor. Dito kasi sa dasyon and pago, parang act of novation, di ba? Kasi ang object niya is sum of money, pero in-extinguish mo siya by payment in kind. Okay, the last special form of payment is the what we call tender of payment and consignation. By the way, sa tender of payment and consignation, meron tong dalawang stages. Tender, okay, which is extrajudicial, saka yung consignation, which are judicial. By the way, pag sabing tender kasi, this is an act of offering payment, meaning the debtor is asking the creditor to accept payment. Now, if the creditor refuses to accept payment without any justifiable reason, then you may now proceed to consignation. And consignation is the act of depositing the object into court disposal. Kaya sabi nga ng Supreme Court sa case ng Limca versus Teodoro, tingnan mo, tender is the act of offering the creditor what is due him together with demand that the creditor accept the same. Pero pag consignation is the act of depositing the thing due with the court or judicial authorities whenever the creditor cannot accept or refuse to accept payment. It generally requires a prior tender of payment daw. Now, by the way, general rule ha, kailangan may prior tender muna. Ngayon, tapos susundan ng consignation. Kasi pag nag-tender ka, tapos yung creditor ayaw tanggapin yung payment without any justifiable reason, then susundan mo siya ng consignation in court. Pero ang problema, meron tayong instances na even there is no prior tender, mere consignation lang, sufficient na for the extinguishment. And what are those? Number one, when the creditor is absent or unknown or does not appear in the place of payment. Okay, obvious naman to, di ba? Kasi kung halimbawa, hindi nagpakita yung creditor at the place of payment or absent siya, how can the debtor make a tender? Eh, di ba pag sinabing tender, tender is an act of offering payment. Meaning the debtor is asking the creditor to accept the payment. Pangalawa, when the creditor is incapacitated at the time of payment. Di ba sabi ko kanina, pag ang creditor at time of payment is incapacitated, payment yan at your own risk. Kaya yung payment is not valid. Except when he kept the thing delivered, and second, to the extent that it redounded to his benefit. Kaya kung ako yung creditor, ako yung lumalabas na debtor dito, ba't ko babayarin yung creditor na incapacitated? Huwag kang mag-ordinary payment. Ang gagawin mo is consignation in court. I-deposit mo yung object sa court. At hindi kailangan ng prior tender dito because hindi naman maintindihan ng creditor yung nature ng tender mo. Kasi nga, incapacitated yung creditor. Kaya even without prior tender, mere consignation lang, sufficient na. Itong number 3, magulo to eh. Creditor refused to give receipt without just cause. Okay, ang problema, if the creditor refused to give receipt without just cause, it means there is a prior tender. Eh di ba pinag-uusapan natin dito, kahit walang prior tender, mere consignation lang, sufficient na. Eh kaso, when the creditor refused to issue receipt without just cause, nagkaroon ng prior tender dito. Kaya mahirap siyang i-reconcile. Pakitandaan nyo na lang yung number 3. Pero by the way, if you look the book of Justice Paras, hindi rin masyadong in-elaborate yun. Hindi in-elaborate yung dito. Saka hindi rin nga ma-reconcile. Pakitandaan nyo na lang to. Yung number 4 naman, when two or more person claim the same right to collect. O example halimbawa, may dalawang creditor. Si creditor A, nagdi-demand sa aking i-deliver yung specific object. Si creditor 2, nagdi-demand rin na i-deliver sa kanya yung same specific object. Etong problem, if I deliver the object to creditor 1, i-demanda ko ni creditor 2. Pag dineliver ko naman yung object kay creditor 2, i-demanda ko ni creditor 1. It means I am opening myself for a possible lawsuit, kaya wag kang mag-ordinary payment. I-deposit mo yung object sa court disposal, then mag-file ka ng interpleader case. Then another is title of obligation daw has been lost. O example meron akong 10,000 sacks of rice, dineposit ko to sa warehouseman, and the warehouseman issue a negotiable warehouse receipt deliverable to bearer. Ang problema, nawala po yung warehouse receipt. Binalikan ko si warehouseman, and I am demanding for the release of the 10,000 sacks of rice. Ang question yun, if you are the warehouseman, will you release the 10,000 sacks of rice? Of course, the answer is no. Kasi ma-open ka for a possible litigation. Kasi ang nakalagay sa warehouse receipt, i-deliver mo yan sa bearer ng warehouse receipt. Eh kung dineliver mo yan dun sa original depositor, edi you can be held liable by the person or party in possession of the negotiable warehouse receipt. Now, since title of obligation has been lost, then Okay, hindi kailangan ng prior tender. You may consign the object in court. Okay, now what are the requisites of a valid tender of payment and consignation? Una is existence daw ng valid debt which is due and demandable. Kaya tingnan nyo, dapat due and demandable kasi baka mamaya, ang due date pala niya next month pa. O, nag-consign ka, invalid ang consignation mo. Kasi justified yung creditor not to accept payment. Tapos tingnan mo, dapat existence ng valid debt, hindi existence ng valid right. Kasi magkaiba ang right sa debt. Kasi pag right yan, hindi kayo required mag-observe ng rules on payment kasi hindi siya obligation. Unlike pag debt, you need to comply the rules on payment na kailangan yung payment must be complete or total, tapos dapat due and demandable siya. Okay, at legal tender. Next, by the way, ano nga ibig sabihin pag sinabi kong right kasi class ibig sabihin ang pinagkaiba niya, pag right kasi, pwede mong i-exercise mo yung right or i-abandon mo yung right. Samantalang sa obligation, wala kang option kasi you need to comply your obligation. Now, ang example ng right class is sa pacto de retrosale, yung tinatawag natin right of repurchase. Okay, etong right of repurchase, hindi to obligation. Kaya hindi compelled na i-exercise mo to. Kasi right nga siya eh. Dalawang option mo ngayon dyan. Kung halimbawa ko si vendor a retro, bawa, binenta ko yung parcel of land sa'yo for 10 million, ang agreement may right of repurchase within 5 years. Okay, kaya since right of repurchase, dalawang option ko dito. Either i-exercise ko yung right of repurchase or i-abandon ko lang siya. Hayaan ko lang mag-lapse yung period. Hindi kasi siya obligation. Unlike pa obligation nga, wala kang option. You need to comply your obligation. O, kaya tingnan nyo maigi, baka mamaya right pala yun. O, hindi kayo required mag-observe ng rules on payment dyan. Pangalawa, tender of payment by the debtor. O, dapat may tender of payment ka. Okay, unless nag-fall sa exception na hindi required to. Refusal without justifiable reason by creditor to accept it kasi baka mamaya hindi pa pala due and demandable, kinonsign mo, invalid yung consignation. O kaya yung payment niya, partial pala yung ginawa ng debtor. O nagkaroon ng subsequent consignation, invalid rin yan kasi justified yung creditor not to accept payment. Tapos may previous notice of consignation to person interested in the fulfillment ng obligation, guarantor, mortgagee, solidary debtor, solidary creditor, consignation, saka subsequent notice to the interested party. Okay, to summarize, para mas madaling tandaan, o ganito na lang ha, tender, notice, consignation, notice. Dapat ma-comply yung two notice requirements. Kapag hindi nyo na-comply substantially all the requirements set forth here, it means the consignation is invalid. 1259, the expenses of consignation when properly made thou shall be charged against the creditor. Ibig sabihin, pag proper yung consignation, yung litigation cost chargeable to the creditor yan. In fact, kahit di mo nabasa to, dapat matandaan mo yung binanggit ko kanina. Pagdating sa judicial cost, chargeable to the losing party yan. And if the consignation was proper, it means natalo yung creditor. Kaya yung litigation cost, chargeable to the creditor. Pero kung consignation is not proper, it means chargeable to the debtor. Okay? 1260. Once the consignation thou has been duly made, the debtor may ask the judge to order the cancellation of the obligation. Okay, question class. Ako yung debtor, ikaw creditor. Di ginawa ko ganito. Tender, notice, consignation, notice. Na-comply ko lahat ng requirement. Ang tanong, is the obligation extinguished? The answer is no. Why? Kasi judicial to. Kaya once na-comply ko na yung condition, then I can now ask the court to issue an order declaring that consignation was proper. Kaya hanggat di pa nag-i-issue ang court ng judgment declaring that consignation was proper, it means the obligation remains. Okay, question. Nag-tender ako, tender, notice, consignation, notice. Okay, and later on the court, render judgment declaring that consignation was proper. Okay, anong effect? Obligation ng debtor extinguished. Okay, baguhin ko ulit. Nag-tender, notice, consignation, notice. Pero yung court hindi pa nag-i-issue ng order declaring that consignation was proper. Question, can the debtor withdraw the object as a matter of right? The answer is yes. Pwede kong i-withdraw yung object. Pero pag withdraw mo siya, the obligation remains. Nandun pa rin siya. Kasi wala naman declaration that consignation was proper. Walang declaration that the obligation is now extinguished. Kaya pwede mo siyang i-withdraw as a matter of right. Pero kung halimbawa, nag-issue na ang court ng order declaring that consignation was proper, hindi mo siya pwedeng i-withdraw as a matter of right. Pero pwede mo siyang i-withdraw with consent ng creditor. Pero ang effect, marirevive yung obligation ng debtor. Pero yung co-debtor, guarantor, surety daw, release na sila. Kasi hindi naman sila nag-consent, okay, dun sa, okay, pag-withdraw ng debtor. Kaya nga sabi ng 1261, if the consignation having been made, the creditor should authorize the debtor to withdraw the same. He shall lose every preference which he may have over the thing. The co-debtor's guarantor surety shall be released. Release from liability. Pero yung share nung okay debtor na nag-withdraw with consent ng creditor, revive siya. Yan yung sinasabi na okay book ni Senator Tolentino. Magkakaroon ng revival ng obligation once na withdraw ng debtor, even with consent ng creditor. Okay? Break muna tayo. Okay? Stop muna. Ito yung susunod nating topic. Okay? On a separate video.